Hello and welcome to Law and Society. So, Jack Smith has responded to Donald Trump's motion to stay the ruling of the DC Circuit, saying that he doesn't have any immunity from criminal prosecution, thereby asking for a stay for the underlying criminal case to going forward. At the risk of being repetitive, I, because of the risk of being repetitive, I am not going to go through Jack Smith's entire filing, but I will read you the first beginning intro statement, and then I will discuss briefly what Jack Smith asks for and why the Supreme Court needs to uh, provide some expediency to this particular ask for stay. They need to rule on it. They need to rule on it fast because there is a compelling interest in the public seeing a speedy trial, and the government has a compelling interest to try cases in a speedy manner, in a timely manner, because otherwise, uh, the witnesses and the trial procedures and the evidence, they all get backlogged, and witnesses don't may not recall what they have previously stated, and there are many other reasons for which a delay is against the best interests of the government as well as the people of the United States. So if you're new to my channel, please like and subscribe, and let's get into it. The Special Counsel, on behalf of the United States, respectfully submits this opposition to the application for a stay of the mandate of the Court of Appeals pending the filing and disposition of appellant's forthcoming petition for a writ of certiorari. The stay should be denied because applicant's failure to meet this court's settled standards. The application stems from an indictment returned by a grand jury against applicant, a former president of the United States, charging him with federal crimes committed in an alleged effort to perpetuate himself in power and prevent the lawful winner of the 2020 presidential election from taking office. The charged crimes strike at the heart of our democracy. A president's alleged criminal scheme to overturn an election and thwart the peaceful transfer of power to his successor should be the last place to recognize a novel form of absolute immunity from federal criminal law. Applicant seeks a stay to prevent proceedings in the district court from moving towards trial, which the district court had scheduled to begin on March 4, 2024, before the applicant's interlocutory appeal necessitated postponement of that date. Applicant cannot show, as he must to merit a stay, a fair prospect of success in this court, meaning the Supreme Court. Nor can the applicant show that the balance of equities or the public interest favors continued delay of the criminal proceedings. To the contrary, the equities and public interest strongly disfavor a stay. Applicant's interlocutory appeal placed the district court's proceedings on hold, thus delaying the trial and verdict in this case. He has no entitlement to a further stay while seeking discretionary review from this court. Delay in the resolution of these charges threatens to frustrate the public interest in a speedy and fair verdict, a compelling interest in every criminal case, and one that has unique national importance here, as it involves federal criminal charges against a former president for alleged criminal efforts to overturn the results of the presidential election, including through the use of official power. Recognizing that applicants' claim of immunity implicates fundamental issues about the role of the president, the government filed a petition for a writ of certiorari before judgment for before judgment to provide this court with the opportunity to resolve applicants' immunity claim at the earliest possible juncture. The court denied review to the extent that this denial reflected an inclination not to review the applicant's claim of absolute immunity from federal criminal prosecution. The court should likewise deny this application and any forthcoming petition, especially now that the Court of Appeals has unanimously affirmed the denial of immunity in a thorough opinion that correctly rejects applicants' arguments. If, however, this court believes that applicants' claim merits review at this time, the government respectfully requests that it treat the application as a petition for a writ of certiorari, grant the petition, and set the case for expedited briefing and argument. An expedited schedule would permit the court to issue its opinion and judgment, resolving the threshold immunity issue as promptly as possible this term, so that if the court rejects applicant's immunity claim, a timely and fair trial can begin with minimal additional delay. The government proposes a schedule that would permit argument in March 2024, consistent with this court's expedition of other cases meriting such treatment. So as you can see from the introduction, that Jack Smith talks about this delay that is being caused by Donald Trump's various petitions and various motions. So Donald Trump is going to keep trying to delay it. And here, Jack Smith is asking the court that if you are to stay the judgment of the lower appellate court, please treat Donald Trump's application for a stay as a writ for certiorari, meaning a writ to review the case on the merits, so that you may be able to set the schedule and do so in a manner that would allow the lower court's trial, substantive trial, underlying trial in this case, to move forward because of the compelling public interest in having resolved this trial, because this has a unique place of national importance, that the public has an interest in a speedy resolution of the case. And there, in this 40 plus page, 50 page response, there's of course the statement of facts, and then the background of the case and how the proceedings went in the lower court and then in the appellate court. And then comes the argument that for all the reasons for which Jack Smith is asking this court first to not stay the ruling and effectively deny Donald Trump's ruling and let the lower court case go forward, or to fast track whatever appeal they're going to have and resolve the case. So we see here that the Supreme Court asked Jack Smith for a reply on the 20th, I believe, and Jack Smith replied within one day. Giving Jack Smith that week to reply to Donald Trump's motion for a stay seems to be that the justices still think that there's plenty of time to play around with this. But Jack Smith's response here makes it clear that time is of the essence. And in part of the statements, in part of the argument, Jack Smith says that if the public interest is not served by a speedy trial and it takes long, witnesses may forget what their memories and their recollection. That weakens the case, and it uh, it is unfair to the administration of justice and to compliance with the law that requires that we allow this proceeding to move forward as fast as possible. Mind you, Donald Trump will have all of the protections that any other criminal defendant has. And he has to be found guilty beyond a reasonable doubt by an unanimous jury. So there is a lot of hurdles for the government to, to be able to actually get to Donald Trump being imprisoned or being convicted for the crimes alleged. But what Jack Smith is saying here is let us at least get to those facts. Let us, at the trial court, have a finding of fact through evidence and the rules of evidence so that the public and the United States government can know for a fact what happened, and then that can be appealed back to the Supreme Court. So I would expect that the Supreme Court would ask for a response from Donald Trump's team and give them the same time, a week. And I would expect that Donald Trump's team will probably take a week to respond to Jack Smith's brief, and then they're going to set a hearing probably in another 2 weeks. So by the end of this month, there's a hope that SCOTUS would hear the case if it chooses to hear the case and listen to the government's request of treating this application for a stay as a writ of certiorari, meaning a writ to review. And if they follow this procedure, then there can be sort of a hearing and then an outcome by the beginning of March. Then finally, the substantive criminal case, the charge of conspiracy to defraud the United States, conspiracy to obstruct, then the charge of obstruction and the charge of depriving rights under the color of law. So depriving American citizens of their right to vote under the color of law by the misperception of the law. So those are the substantive cases for which this case needs to move forward and the immunity needs to be resolved. And so Jack Smith is asking the Supreme Court for expediency. And I sure hope that we get a resolution one way or another by the first week of March, because then the case can still go forward and resolve before, election season kicks in, and the American public will have truth from the courts and a verdict to be able to assess what the truth is and then make their decisions on who to vote for and who to believe. So with that said, I don't see any questions. Thank you so much for the 4 of you who are here. If you're new to my channel, please like and subscribe and do share. It is the lifeblood of the channel to be recommended by people who watch. I rarely go into it in detail, but YouTube's platform is entirely based on what you want. It's not what I want you to hear. It's what you want to hear. So when I get a response from you through likes or unlikes, and when I get comments, when I get that engagement, it helps me gauge what content to provide for you. And because today is sort of an intermittent, an interim episode, because there's not much of substance talked about, I can give a little time to explaining why it's so important for you, the viewer, to engage with my video so that I may know whether I'm in the right direction or not. Because ultimately, I'm here to parse the legalese and make it easier for you to understand what is happening with Donald Trump's criminal prosecution. I'm focused on the DC case, so I'm not really going that much into the other ones quite yet. There is a hearing on Fani Willis's disqualification in the Georgia case. There's a hearing in the Manhattan hush money criminal trial that's ongoing. And I think Eileen Cannon is up to her antics, and she has come to a point where Jack Smith may ask for recusal. So, and Judge Engoron will render a verdict on the civil case of fraud expected on Friday. So this month will be packed with court proceedings and responses, and I will do my best to keep up with it. With that said, thank you so much. Hey, Deb, thank you for being here. Please, again, do like, do subscribe, and do share. It helps me out a lot. To end, I would like to say that the whole time, if you had heard a loud snoring noise, it was the beast that you saw behind me just now. He was snoring through my reading. So now he has woken up and he expects me to go and pet him. And that's what I shall do. Thank you so much, and I will talk to you soon.